Kaiser, not in your course materials, but at item number 29 of the supplement, deals with the question of what happens when you do get a jury trial, but you don't like the result. And here, specifically, the defendant, our familiar Kaiser Hospital, was a party to a medical malpractice action. During the course of the jury selection process, the plaintiff's counsel utilized some, but not all, of her peremptory challenges to excuse members of the jury panel who were also members or subscribers in the Kaiser Hospital system, but failed to exercise a peremptory challenge as to a number of other members of the panel, including some who actually ended up on the jury. After the result came in, and as you might imagine, it was a defense verdict, an appeal was brought on the grounds that the trial court should have excused, as a matter of cause, not a peremptory challenge, but a matter of cause, any members of the panel who also happened to be subscribers or members of the Kaiser system. The Court of Appeal held, sorry plaintiff, that's not going to be the law. Although a litigant is not required, the court held, to show actual bias in disqualifying members of the panel for cause, they must show that there's some actual interest in the outcome, and here there was no such showing. Kimberly versus Kaiser is probably also weakened in terms of its precedential authority on this issue by the fact that plaintiff's counsel did accept the jury as impaneled, even though plaintiff's counsel knew that it contained members of the Kaiser system and accepted the jury, said it was fine, probably found to have substantially waived its right to raise that issue on appeal. All right, Steve, new in evidence this year.
Dealing with the next case on page 57, that's Barnes versus Wood. This is the continuing saga of the plaintiff's bar attack on the MICRA statute. That's the Medical Injury Compensation Reform Act of 1975. This case upholds the constitutionality of that provision, which allows the medical malpractice defendants to introduce evidence of the plaintiff's receipt of payments from collateral sources such as health insurers and workmen's compensation carriers. Further, the collateral sources mentioned in the statute are barred from recovering those payments from either the plaintiff or the defendant. That has been upheld as being constitutional by the California Supreme Court. The next item on page 60 is not in your materials, but I'd like you to jot it there, and that's Evidence Code Section 1511, which provides for the first time that duplicates are admissible in actions in California. As you know, before, duplicates have not been admissible. They are now admissible under this Evidence Code section, Evidence Code Section 1511, unless, and there's only two exceptions, unless a genuine question is raised as to the authenticity of the original, or in circumstances in which it would be unfair to admit the duplicate in lieu of the original. I'll submit to you that that means that in 98% of our cases where there's really no question about the authenticity of the duplicate, that we're now going to be able to use the duplicate rather than always having to worry about where is the original, my God, is it here in time for trial, where is it on the motion, on the hearing of the motion for summary judgment. We're going to be able now to rely in most instances on the duplicate statute. That's Evidence Code Section 1511. Bob, what's new in the area of statements of decision?
What's new is more confusion and another can of worms, which is not too much more complementary to the legislative drafting process than that in request for admissions discussed earlier this evening. CCC Section 632 sets forth the procedural and timing requirements for requesting a statement of decision. 632 replaces the earlier provisions in the code relating to requests for findings of fact and conclusions of law. 632 says that you are required to request a statement of decision within 10 days of the court's issuance of a notice of intended decision, or, in the language of the statute, if the trial has lasted less than 1 day, then you must make your request prior to the submission of the case for decision. So the time that you have in which to request it turns, theoretically, on the length of the trial, even not on the magnitude of the issues involved or the amount of money involved or the kind of relief at issue. So there's a kind of simple-minded legislative assumption that if a trial lasts a lesser period of time, that somehow you ought to move more rapidly to request a statement of decision. Well, as we can see, that kind of assumption gets the court into some trouble. There are 4 cases that deal with a request for admissions that we're going to talk about this year. And I'll divide them into 2 subjects. One is when you have to ask for it, and the second is what it has to say. And they both involve, in one way or another, the pithy metaphysical question of how long is a day. Beverly versus Beverly versus Briscoe, which appears at page 61 of your course materials, is a when you have to ask for it case, and that should be contrasted with Mitchell versus Orange, which is item number 30 on your supplemental citations list. In Beverly, the hearing lasted only a few minutes. However, the proceedings required the judge, the trial court judge, to read and review the record of the proceedings which had occurred below. It was an administrative mandamus proceedings. The court had to read an administrative record, and that required the judge to engage in the reading process for more than a day, even though the parties were in court for only a few minutes. The Court of Appeal held that that was a trial which lasted more than a day, and consequently, the party seeking a statement of decision had 10 days from the notice of intended decision. Compare or contrast that with Mitchell versus Orange, in which no statement of decision was found to be required when the hearing lasted a total time of less than the equivalent of a court day. In fact, it lasted less than 3 hours, but it was one of those cases which was tried in pieces and was continued over a period of 2 or more days. So the hearing lasted less than 3 hours. The parties were in court on more than 1 day. The court said you had to make your request at the time that the matter was submitted for decision. How you reconcile Beverly and Mitchell versus Orange is beyond me, but that's what the courts of appeal are telling us this year. Then, the next question on statement of decision, what must it contain? This is the kind of the rose by any other name concept in Miramar, which appears at page 61 of your course materials. There, the court issued a notice of intended decision, which was conclusory in nature, but put the label or title on it, statement of decision. The Court of Appeal said, no, that's not enough to be a real statement of decision and to satisfy the requirements of 632. It must set forth the court's legal reasoning and factual basis upon which the decision was reached. Compare that with architects and contractors, item number 31 in your course materials. There, the court held that when the trial judge read a decision in open court on the record, it set forth the court's factual and legal reasoning. That satisfied the requirements of the statute. Although it was not in technical compliance, it was harmless error not to couple the oral statement of decision with a written statement of decision. These decisions here in Miramar, Beverly, Mitchell versus Orange, and architects and contractors really are issues that could easily be resolved by some little redrafting of Section 632, and maybe when the commissions are done working on the discovery statute, they can work on this. All right, we're going to turn to Steve Sumnick now on the subject of judgments and summary judgments. How do you say that?
Page 63 of the materials, Craven versus Kraut. That case stands for the proposition that you cannot make a motion to periodicize payments in a medical malpractice case after the judgment has been entered. Next case, Continental Insurance Company versus Superior Court, is a very good case which all of us have been waiting for a long time to come down. It deals with a summary judgment motion and what the trial court must do in denying a motion for summary judgment. How many times have you spent hours preparing a motion for summary judgment that was very valid? You've gone out there thinking that 9 times out of 10 you should win that motion, or even 10 times out of 10 you should win that motion for summary judgment, only to have the trial judge say, very briefly, very quickly, and without explanation, denied, triable issue of fact. This case says, trial judge, no longer can you get away with that. You now have to, under the Continental Insurance Company versus Superior Court case, specify your reasons. Not only do you have to specify the reasons, but you have to state what fact was in issue, and also what conclusion of law that related to make sure that it was not an issue that was any longer in the case or was still open as a triable issue of fact. So it really requires the trial court judge to give some great specificity to his order denying the motion for summary judgment. I think you'll see trial